The applicants have approached this court under Article 3 of the Convention on the Establishment of a Gaussian Human Rights Court, read with the appropriate article which allows an authorized non-governmental organization to represent a group of claimants. Your Excellencies, as counsel here, I will be we will be putting forward three primary contentions. Firstly, that Livokia has human rights obligations in respect of Algora. Secondly, that Livokia has violated the human rights of the applicants. Thirdly, that the applicants are entitled to remedies from the state of Livokia. Now, Your Excellency, the overall control test...
It's a more rigorous test from the point of view of your case, is it not?
Yes, Your Excellency.
Effective control is more rigorous for you to establish than overall control.
Your Excellency, what counsel...
And it's your position that you want to prove from the facts.
Yes, Your Excellency.
That more rigorous test is in fact the kind of control.
Yes, Your Excellency.
All right, and I'm going to allow you more time because questions have
certainly
taken some of the time.
Your Excellency, before I continue, if I could just lay down what is the effective control test as has been codified, so to speak, you could say, in the ILC draft articles. I now accept it as the articles on state responsibility. Firstly, it states that that responsibility is to be attributed to a state if, on the basis of actions by certain individuals in other territory, on the following basis. Firstly, whether the state has issued instructions to those persons. Secondly, whether the state has directed the persons to do something. Or thirdly, whether the state has exercised control over those persons.
Some of the remedies that the councillor would like to request from the court are the right to return. This is a concept that has been discussed under Article 13, Clause 2 of the UDHR, 5D2 of the Convention on All Forms of Racial Discrimination, and 12.4 of the ICCPR. And it has been held that this is not just for the individual, but is applicable en masse when a large number of aliens or people are being expelled, and this is applicable to non-nationals as well. It is not just the right to return to your home country or to your national land, but to any country where you had long-term residence, whether by birth or for working, and and there are several.
Is the right to return dependent on whether they have been correctly expelled?
It would also depend on that, yes.
If they were correctly expelled, would you be speaking of a right to return?
If they were correctly expelled, and once again the due process was followed, and it seemed to be a fair reason, and it was actually a threat, an imminent threat to the security of Livokia and Algora, then I would understand, the council would understand that the right to return would not seem like the correct option. But since that is not the case, the council would request for the right to return.
All right.
Thank you. Will you conclude now, please?
Okay, I'll just go through the prayers then. In light of the issues raised, we would like to, for the court to accept that Livokia has human rights obligations in respect of Algora, that Livokia should allow the right of return, and that the refusal of Livokia to allow this and to facilitate the return of displaced Galopians is a violation of the prohibition against discrimination and the right to family guaranteed by the conventions that have been mentioned. Moreover, I would also like to present the last contention, which I did not really get to argue. That was that the looting and the unlawful appropriation of homes and property belonging to the displaced ethnic Galopians in Algora violates human rights law. And compensation to the displaced Galopians because of the loss of work, the costs faced because of expulsion, and the loss of property. They should be given compensation.
Counsel for respondent.
Your Excellencies, our issues are pretty straight and forward. The basic two issues that we shall be handling are that Livokia is not responsible for any systemic human rights violation. Number one, that I'll be handling with. And the second issue that my co-counsel will be handling is that it has no responsibilities for the actions of the sovereign state of Algora. But before we can actually move into these issues, it's necessary to see whether worthy opponents have a locus standi to approach this honorable court. A thunderbolt without the rolling of thunder would not much frighten men, though the danger lies in the lightning and not in the noise. Jules Verne and 20,000 Leagues Under the Sea. The reason I use this quote is the context that when we delve deep into whether Livokia is actually responsible, we fail to look into the matters, whether the worthy opponents, their claims, are to be allowed in before this honorable court. And the reason being, the authorization clause, if you could just look into paragraph 5 of the fact sheet, it gives a specific authorization clause which says unless the NGO is specifically authorized, it may not come. It asks for a definite class action.
We have had a look at your memorials, and quite frankly, I'm very concerned about this point that you're raising, because my understanding of the facts is that it's extremely clear that counsel for the applicant, the NGO, has been properly authorized to appear before this court. As far as I'm concerned, your argument really just turns on semantics.
Your Excellency, I'd like to beg to differ, because the mere fact that is said is on behalf of 300 displaced Galliopians. It's vague.
Counsel, let me interrupt you. This is a human rights court.
Indeed, Your Lordship.
Yeah, we have different rules, and we've already allowed the applicants
Indeed, Your
their application. So take note of what I'm saying to you. Is use your time to address us on what you said you will argue, that the state of Livokia did not commit any violations. We're very interested in that area.
Indeed, Your Excellency, I'll move on to that. Can I just finish up this thing?
Well, it's your time that
Make
you...
the point, you know.
Indeed, Your Excellency, I'll move on.
Understand it.
My first argument proper is Livokian exercise of sovereign rights to expel suspected aliens does not constitute human rights violation. Now, citing national security, every state has a pro bono right to expel aliens. In fact, one of the basic rights possessed by the supreme power in every state is the right to refuse to permit an alien, I'm quoting, to enter that state, to annex what conditions it pleases, to permission to enter it, and to expel or to deport from the state at its pleasure, even a friendly alien, if it considers its presence in the state opposed to peace, order, and good governance. This has been held in the case of Attorney General versus Canada versus Kane, is a 1906 judgment.
Next point I want to counter is to my opponents is the right to property. They have claimed in their...
Just before you move on, I mean, you've cited quite a lot of writings of various international scholars. To what extent should this court take those into account?
Your Excellency, in international law there is nothing called binding authority. So it's all about persuasive arguments, what I should present, what I feel is relevant to this case I have presented. Another important point I want to counter is the right to property that has been claimed by the opponent counsel, which generally they have claimed unlawful appropriation of property with regard to the acquisition, transfer, and loss of ownership rights. Your Excellency, can you please turn to page 10, footnote 51 and 50 also. There are two citations. One, the 50 is Vilkov, Nationalization and International Law, 1960, Soviet Yearbook of International Law. The second is the UN Economic and Social Council report on the Secretary General. These two reports, as per the general presumption of the international law, clearly states that only municipal law can regulate property matters, and this property matter shouldn't be entertained as a part or a subject in the international law.
All right, thank you. We've taken the point. Your time is up some time ago.
Council begs pardon to please extend 2 minutes. Just to finish it off.
2 minutes is a long time.
We were told not to give extensions.
Yeah, no, I'm sorry, we can't give you an extension. Thank you.
Okay. Can I move to the prayers?
Thank you. Otherwise, you go for contempt of court if you keep pleading. Thank you very much.